we know that this very court, and just 10 years ago in a very modern decision, said that misrepresentations on the application about age and the number of prior marriages could be the basis for voiding the marriage on the basis of fraud, but it didn't make it void ab initio. So in that particular...
Well, so I'm trying to go into Judge Usman's question, though, about how far we open up this question about when a marriage can be annulled. The limiting factors then would be age. I think everybody would agree under the statute that's one of them. You'd say we would look to that Supreme Court case from '39 as an additional prudential ground, and then anything to do with the license. Is that what you're? I mean, I'm just trying to determine what the scope of when it's appropriate to consider annulment versus divorce.
Sure. And I'd first, Your Honor, think it'd be appropriate to divide grounds for a void marriage from a voidable one. I think that distinction that is set out in detail in Meeks is an excellent one. And there are certain grounds to avoid marriages ab initio. The ones that would apply here for avoidable marriage are things like the financial misrepresentations that we saw in the Basket case, or in the 1928 case, the Cannon versus Cannon case, an annulment was upheld on the basis of duress. That was a case where the father of the bride thought that maybe the son had done something inappropriate with the daughter and threatened him with a shotgun, and so there was a marriage that was later annulled because of duress. And then I think we can obviously go back to Meeks. I mean, if you actually make misrepresentations to your spouse or to the clerk's office about yourself or your history, that can also be the basis for a voidable marriage. And here,
does that open up? I mean, I'm dating my wife, and I kept my apartment cleaner when she came over. Am I misrepresenting myself in a way that? And I like to travel, and I really don't like to travel as much as I may have let on. And are we opening this up for annulment in an incredible number of circumstances when it's somebody
or didn't care for cooking as much as we suggested while we were dating?
My mother-in-law is my favorite person. Are we opening this up for these things that may matter a great deal and understandably to people, but really should not be anywhere near being a basis for why we say a marriage never truly occurred?
I have two responses, Judge Usman. First, let's not lose sight of the fact that what the court instructed the jury is not Tennessee law. It is not even arguably Tennessee law. But coming back to the second point, coming back to your question, is that the way that we handle this is what our Supreme Court, what the Court of Appeals said in the Cole versus Cole decision, which we cite, which is that under our Tennessee statutes, marriage is a civil contract, and it is subject to being dissolved on the basis of regular defenses to a contract. And here, where you have annulment by fraud, if you prove that there is a misrepresentation of fact that was material, that a party relied on, where the reliance was reasonable, and then the party acted in reliance to his detriment, that is grounds for an annulment. It has to be proven under the Guzman decision by what they call cogent and convincing evidence, but it has to be an analysis that actually respects the fact that marriage is a civil contract. That's what our statutes say. That's what our Supreme Court has said repeatedly. And here, the misrepresentations were not minimal. They had to do with the wife's alleged commitment to the marriage, had to do with history that is laid out in some detail in our briefs. So I certainly agree with the court that you cannot take a rather mundane, immaterial type of statement and use that as a basis for annulling a marriage. But our cases don't suggest that. But just look historically at what our courts have said about when marriages can be annulled based on misrepresentations. We've got Southern Railway, obviously, versus Basket. We've got the language in Ray Estate of Meeks. We've got Coulter in other cases. And that's, I would submit respectfully, the guide that the court should use. Thank you.
Thank you.
Good morning. Good morning. It please the court, I'm Jim Weatherly. I represent Ms. Dana
Purdue. She was restored her maiden name as the result of the divorce action, along with Jackie Dixon and Catherine Kimmel, who are here for my firm. As I was attempting to put together my remarks for today's proceeding, I thought, in 15 minutes, how do I summarize 8 years of litigation and 90 volumes of record that have been presented to the court? And with, again, all due respect to my very capable and competent opposing counsel, I think the court should be focusing not on just the issue that he tries to raise in this, with all due respect, somewhat of an esoterical discussion about what is annulment, and look at the facts of this case and how we got here. We tried to do that in our brief because we didn't want to be pulled into just the issues that Mr. Pagliara wanted to raise. And if the court would indulge me just for a few minutes to go over the history of this, these parties met in July of 13. They decided to marry in they met in 13, decided to marry in July of 15. But before they married, Mr. Pagliara, who is an attorney, who is according to him, the top-rated financial advisor in the state of Tennessee, presents to Ms. Pagliara, Ms. Purdue at that time, and a nuptial agreement, and says this will be signed or there'll be no wedding. Now, there's no suggestion of duress. It's just he was the author of this agreement. He was the one that presented it to her, and he was the one that demanded that it be signed. She goes to an attorney, Marlene Moses, they discuss it, she comes back, she signs it. They get married in July of 2015 in Hawaii. I won't go into what happened in September of 16. That's in the record, and with all due respect, I'd like to reserve that for purposes of later discussion if necessary. But Mr. Pagliara was the first to file for the divorce, and he seeks in his divorce action a divorce. I believe at that time he sought enforcement of the antenuptial agreement, but I'm not remembering that perfectly clearly. But he then dismisses his action. Ms. Purdue files her action in December of 16, and she seeks a divorce and enforcement of the antenuptial agreement. Paragraph 9 of the antenuptial agreement specifically states that in the event a party files such an action and seeks enforcement of the antenuptial agreement, the other party will not contest the action. She's relying on the provisions of the agreement that Mr. Pagliara has drafted. So in January of 2017, which is a month after she's filed for the divorce, he comes to her house and demands that she turns over the keys to her car. Now, this car is a 2016 BMW X5, $78,000 vehicle that he gave to her as a wedding gift. He tells three people, tells two other witnesses that this was a wedding gift, and it was also the car that she regularly drove during the marriage. The antenuptial agreement provides that in the event of a divorce, the parties get their separate property, which we submit was gifted to her, or she gets the vehicle that she regularly drove during the marriage. That's his first breach of the agreement. He comes there in January and forcibly takes the vehicle from her. In February of 17, he files an answer and a counterclaim. His answer does not comport with the requirements of the antenuptial agreement. He denies that she's entitled to a divorce. He denies and moves that the action be dismissed. Now, that's not cooperating. That is contesting her action. That's his second breach. He then seeks his own divorce and an annulment and does seek enforcement of the antenuptial agreement. He then proceeds to file this motion for partial summary judgment in which he's seeking to validate the antenuptial agreement. Basically says by affidavit that it's valid and it's enforceable. Ms. Purdue then files through her attorney a motion for return of the vehicle. Well, when she files the motion for return of the vehicle, he dismisses his motion for partial summary judgment and abandons that action. Ms. Purdue's attorney, Ms. Moses at the time, then files a motion with the court to strike the counterclaim and the answer that has been filed because it is in violation of the antenuptial agreement. The court won't do that. Mr. Pagliara, in his response to the motion, states, I've got the right to seek an annulment in this action, and I'm going to invalidate this antenuptial agreement. And therefore, because it was obtained by fraud, it can't be enforced. Therefore, I'm not liable for it. That apparently, with all due respect to the trial judge, confused the matter to the point that the litigation was allowed to continue. And continue it did. Yesterday was the 2-year anniversary of the jury's verdict in this case, where all issues were resolved in favor of Ms. Perdue and against Mr. Pagliara.
Is it your position then, it's not merely the fact that Mr. Pagliara wanted his own grounds for adult, or alternatively sought annulment, but whether it was the seeking of, well, I guess you've put a laundry list here, the recovery of the vehicle, and the request that her petition be dismissed triggered paragraph 9?
Correct.
Okay. So let's assume neither of those actions happened, and he just said, she's filed a petition of divorce. No, I want an annulment. You wouldn't say that's contesting.
I would.
You would, okay.
I would because the annulment in its form is contesting her right to a divorce. The annulment, if it's granted, is going to result in the marriage having never occurred, which is different. I think we discussed that, or at least a question was asked earlier about that. She had the right to a divorce. She wasn't seeking an annulment. She was seeking a divorce and enforcement of the antenuptial agreement.
Under the antenuptial agreement, couldn't a party seek an annulment? And doesn't the language itself anticipate an annulment being able to be sought?
It does, but in paragraph 9, it suggests that that annulment has to carry with it enforcement of the antenuptial agreement. That's what he didn't do. He abandoned that because he didn't want to see her get anything, with all due respect. Initially, he was saying it should be enforced. He did his partial summary judgment seeking to have it validated, and then he abandoned it.
But I can envision a circumstance under which an annulment would still be consistent with the antenuptial agreement if the annulment said, if the final judgment said, the annulment is granted, but the party shall comply with the provisions of this agreement, just like paragraph 9. I mean, the court could condition the annulment on that.
I agree.
Yeah, okay.
But I think, again, under the terms of paragraph 9.
But you're saying something more was happening here, not just he wanted an annulment, he wanted, which, I mean, again, this is a, I mean, I don't see the motivation here to seek to avoid the antenuptial agreement, because it seems like these terms are very favorable to Mr. Pagliara here. So
Well,
what would be the incentive to do that?
Well, as we mentioned in the brief, what Mr. Pagliara did, and this goes to the concept of the annulment, as I understand the annulment, it is a misrepresentation or concealment of a material fact. And the court gave this instruction that had Mr. Pagliara been aware of this material fact, he would not have married. He would not have entered into this marital relationship. Well, what is he doing to try to get her back into the relationship? He's offered her a 50% interest in the Pagliara trust, granted, undefined as to its value, but he's offered her a 50% ownership interest in the house that he owns, which was valued at $2.6 million. Now, we go back to what the terms of the antenuptial agreement provide, and to your point, Judge McBrayer, she was going to get about $200,000 was what she was entitled to under the agreement. In order to get her back into the marriage, he's offering her millions of dollars in order to come back.
I want to make sure I understand the timeline correct. There was information, there was an allegation that was raised, email, and that email was shared before the marriage initially, right?
Yes, sir.
Okay, so that was conveyed by then future wife to then future husband, even before they married. The details of what happened were not there, but that information about the nature of the relationship, all of that was conveyed.
Correct. Correct. So again, our position, now again, Mr. Pagliara takes issue with that, I think, to some extent. He says it didn't matter to him. He just didn't pay much attention to it. So he uses that as a way of saying I wasn't really aware of what she was being accused of.
I'd like to jump to another issue. If you could talk about the attorney's fees issue here. Can you walk us through how the trial judge got to this conclusion? I'm struggling a bit with how we got to the number that we're at here in terms of the percentage. And what exactly is this based upon here?
The percentage?
The percentage in this case.
Well, I think the percentage is based on the Gorey case, which Mr. Bolso presented to the court as a basis for making an attorney's fee award that didn't look at each and every entry that had been made. So that was the percentage concept comes from the Gorey case.
Do we have any testimony here that suggests that it was 80% that was related to X, Y, and Z? And is there? I'm trying to figure out how the trial judge got to that 80, and it doesn't come across as a sort of pulling a number out of a hat. I mean, how do you get to 80% here?
How does he get up to it, or how does he come down to it?
Either way, I mean, and I understand that trial judge has certain things here that the trial judge didn't view was applicable, but
right.
In breaking down the percentage, how is the trial judge arriving at, or how are we supposed to understand from the record before us, how the trial judge got to the conclusion that 80% was the right mark in a way that doesn't look like random guessing between 100 and 0? Well,
I think we can start. And my recollection is, and the record would better reflect, but Mr. Pagliara's position was that 25% of the fees should not be awarded because they dealt with extraneous issues. Our position was, look, these issues may be extraneous to the concept of annulment, but the facts that he's relying on for the annulment, he also wants to use for this divorce action. Consequently, we had the obligation to engage in the discovery and prepare the defense. He got to the 80%, I think, just based on what he said in his order, and that was he opined that 20% of the effort that had gone into the case was related to either the defense of the infliction of emotional injury, tort claims, and or the preparation, basically, of an abusive civil action claim that we had made and then later withdrew.
Is there anything you can point us towards in the record that would support that conclusion that 20% was the appropriate or place to set that mark? Or 8?
Nothing other than the discretion of the court in reviewing the affidavit that had been presented and I won't say hundreds, but certainly several pages of just individual entries that had been made in the time that had been expended.
And the judge that set the attorney fee number here was the judge that tried the case?
Yes.
Okay. So
Judge Parks.
And so we would give discretion to that judge, having seen the work
right.
done, and to put a number on what they thought the value was here.
Yes, and I would also point out that when Judge Johnson had the case before she recused herself, there had been a previous fee request submitted to her, which she had granted. And it was approximately $150,000, and that was back in 2018.
So was the number that Judge Parks awarded, was that inclusive or in addition to?
Well, what happened with Judge Johnson was that there was a motion filed to reconsider what she did, and then Mr. Pagliara, through counsel, was able to convince her that the language of the antenuptial agreement, which they were saying was invalid anyway, precluded the award of any attorney's fees.
Well, there is a provision in there that just seems to say that we will all bear our attorney's fees, which, I mean, I'm still trying to figure out what the strategy or dynamic here is between wanting to undermine the annuptial agreement because of those various provisions. And I guess that was just a comment. I'm sorry, I didn't have a question.
No, but I would say that award was set aside, such that because again.
So Judge Parks was starting anew.
He was starting anew.
So it wasn't inclusive. Yeah.
In his enforcement of the antenuptial agreement, he awarded the attorney's fees, determined them to be at 80%. Yeah. I say I have 24 seconds left, and I've yet to address any of the issues that I've raised. Does the court have any questions about any of those issues? If not, I'll step aside.
Seeing none.
All right. Thank you very much.
Thank you.
Let me answer your question, Judge Usman. What Chancellor Parks did was, in the post-trial hearing on attorney's fees, he took a declaration that I filed and applied it to the plaintiff's request for attorney's fees. Because recall that we were seeking attorney's fees as well, because we had just won on a motion for judgment notwithstanding the verdict, a divorce on the basis of improper marital conduct, which in our view entitled the husband to recover attorney's fees under paragraph 9. And I had submitted a declaration that went through the different parts of the case, and in accordance with this decision, this court's decision in Gorey, allocated percentages to the different parts of the case. The plaintiff had done nothing. I mean, so there is no evidence of any kind whatsoever in this record upon which Chancellor Parks could possibly have reached a conclusion that plaintiff's counsel was entitled to an award of 80%, because it's very clear from the hearing. What he did was he took my declaration and started adding up my percentages and then applied them to the plaintiff's counsel. And if a trial judge can do that in setting an award for attorney's fees, then we're in the days of the Wild West. There is no record evidence whatsoever to support the amount of the award. But let me also address the fact that any award to wife was impossible to make, because when you look at paragraph 19 of the antenuptial agreement, it specifies that attorney's fees can only be awarded to a non-breaching party. And she ultimately was a breaching party, because despite the fact that we should have gotten a directed verdict in favor of Mr. Pagliara on his claim for divorce on the basis of improper marital conduct, Chancellor Parks let it go to the jury, and somehow they decided against us, even though the evidence was uncontradicted that there was marital infidelity post-separation but during the marriage, which this court has found to constitute, as a matter of law, improper marital conduct. And then we went back and said, after the trial, Chancellor Parks, you should have granted that directed verdict because the evidence was uncontradicted. He agreed, and so he granted our motion for judgment notwithstanding the verdict and granted Mr. Pagliara a divorce on the basis of improper marital conduct, which made Miss Pagliara a breaching party at that point, which precluded her ability to recover any fees under the agreement.
So was there at some point in this litigation where your client took the position that the annunuptial agreement was non-enforceable?
No.
Okay.
From the very beginning, dealing with the very first answer ever filed, in I believe it was February of 2016, Mr. Pagliara's answer says, with regard to the divorce, the annuptial agreement is valid and enforceable. With regard to the annulment, if in fact the annulment that Mr. Pagliara sought were granted, then it would be inapplicable because it would have no job to do, because he was seeking a retroactive dissolution of the marriage. And if you recall the language from the antenuptial agreement, and this is in paragraphs 10, 12, 13, 14, 15, and 16 of the antenuptial agreement, it says that it applies in the event of a non-retroactive dissolution of the marriage, which implies, of course, that it does not apply if the dissolution is from the beginning, if it is in fact retroactive. And that was Mr. Pagliara's position from the very first pleading ever filed, all the way to trial, Judge McBrayer, where we actually entered into a stipulation that the antenuptial agreement was valid and enforceable.
One quick question.
Okay.
The antenuptial agreement seems to anticipate the possibility that an annulment action can be filed, and does it necessarily then invalidate the, and returning to Judge McBrayer's question from earlier, can't you have an annulment with a still binding antenuptial agreement, given the language here in this case? Am I understanding that correctly, or am I misunderstanding it?
If I understand what the court is saying, I believe the court is correct. Under the antenuptial agreement, there are two possibilities. One, you could obtain an annulment which is not retroactive to the beginning of the marriage, in which case the antenuptial agreement controls in accordance with the property division. But implicit in that, of course, is that if you have a retroactive dissolution of the marriage, then there never was a marriage, and so therefore the antenuptial agreement has no job to do. And when you look at Coulter in particular, it talks about the fact that you can have avoidable, you can have a conduct that constitutes grounds for a voidable dissolution of the marriage from the beginning. And that's what Mr. Pagliara was seeking ultimately.
No more questions? Thank you.
Thank you.
Thanks to all of you. And now we're going to take a very, very brief recess to